And I want to welcome everyone to today's webinar from the Mid-Atlantic ADA Center. Today's webinar is ADA and Mental Health in Higher Ed, Current Case Law. And we are very happy to have with us today two attorneys from the Bazelon Center for Mental Health Law in DC. We have with us Britt Vanneman, who is a staff attorney, and Monica Porter, who's a policy and legal advocacy attorney. So welcome, both of you. We're really glad that you're here with us today.
Thanks so much, Carlene. We are excited to be here. My name is Monica Porter. My pronouns are she, her. I am policy and legal advocacy attorney at the Bazelon Center for Mental Health Law. And as Carlene said, I'm joined by my esteemed colleague, Britt. A brief visual description of myself. I am a white woman with brown hair in a bun wearing black framed glasses. We'll proceed now to slide 12. Britt and I, pardon me, to the previous one. Thank you. Britt and I are here from the Bazelon Center for Mental Health Law. The mission of the Bazelon Center is to protect and advance the civil rights of adults and children with mental health or developmental disabilities. The slide we're currently on includes the Bazelon Center's logo, which is a red and blue bee surrounded by text, Judge David L. Bazelon Center for Mental Health Law. We would love to get a sense of who is joining us on today's webinar and are currently launching a poll. The prompt of the poll is tell us about you. And this is a multiple choice question to select a description that best fits how campus mental health touches your life. Option A is higher education student. Option B is higher education staff or administrator. Option C is disability rights advocate. If you are coming in from a protection and advocacy agency, or P and A, from a nonprofit or a civil rights attorney. Option D is higher education advocate, such as from a law firm or working directly in an institution of higher education. Option E is mental health professional, such as therapist, psychiatrist, social worker, or counselor. Option F is parent, guardian, or other student supporter. And of course, option G for other. And it looks like the majority of folks who are joining us today are 66% higher education staff or administrator. We've got a number of higher education students with us today and are so glad to have you. As with 14% disability rights advocates, 4% higher education advocates, 16% mental health professionals, 4% parents, guardians, and student supporters, and 10% other. Thank you all so much for joining us today. No matter how campus mental health touches your personal and professional life, we are happy to be with you to talk about our work, some rights and responsibilities, and current trends. We'll now proceed to slide 13. Before jumping into substance, a quick note on terminology. Terminology we will be using throughout the presentation includes the phrase mental health disabilities. When we say that, we are referring to things like anxiety, bipolar disorder, depression, PTSD, and schizophrenia. You may have heard other terminology. We're using the term mental health disabilities to make clear that folks who fall within this category are protected by disability rights laws. You may also see an acronym on our slides, IHE, and that stands for institutions of higher education, such as community colleges and four-year colleges and universities. We also want to note a brief content advisory. Today's presentation on campus mental health will touch briefly on some sensitive topics, including mental health crises and suicidality. we do encourage you to take space as needed throughout today's presentation. So let's talk briefly about why we are here today. According to a recent national study among students at over 350 schools, in recent years, 2020 and 2021, over 60%, 60, of students met criteria for one or more mental health disabilities, representing a nearly 50% increase from 2013. Within these findings, the researchers identified racial disparities, and though students of color were found to experience mental health symptoms at similarly high rates as white students, students of color were found to be less likely to access mental health treatment. An additional study by Mental Health America of over 450 college students with mental health disabilities, which was focused on their experiences during the COVID-19 pandemic, found that 70% of students with mental health disabilities did not register for disability accommodations. Some of the top reasons that they reported for not registering for accommodations included that they didn't know that they were, quote, sick enough to get accommodations. They didn't know what accommodations are, or they were afraid to talk to professors about accommodations. So that's why we are here today. Slide 14 shows our learning objectives. Our goals today are to talk through rights and responsibilities related to campus mental health, to talk about current trends in how these topics come up and are worked through, and to look ahead to what might come up in the near future. Our hope is that this presentation will be helpful to you no matter how campus mental health touches your life. I'll now turn it to my colleague, Britt, to talk to us about legal obligations of IHEs.
Hi, everyone. Thank you, Monica. My name is Britt Vanneman, and I'm a staff attorney at the Bazelon Center for Mental Health Law. I'm thrilled to be here with you today. My pronouns are she, her, and hers, and I am a white woman with blonde hair that's pulled back, and I'm wearing a floral shirt. Slide 15. So let's dive into the legal obligations of institutions of higher education. Slide 16. So what constitutes discrimination on the basis of disability? When are schools required to provide accommodations for students with disabilities? When are schools entitled to use disciplinary actions or require leaves of absences for students with disabilities? There are three main federal laws that answer these questions. The Americans with Disabilities Act, or the ADA, as I will refer to it from here on out, Section 504 of the Rehabilitation Act, and the Fair Housing Act. Which law applies depends on whether the IHE is a private or public institution and whether it receives federal financial assistance. And we'll go into the definition of those terms in a minute. Just a note before we get started, while we're focused today on these three federal laws, you should also look up any state or local laws which may provide additional protections or different protections from discrimination on the basis of disability. So slide 16, ADA and Section 504. So both the ADA and Section 504 prohibit discrimination against students whose disabilities or disability substantially limit a major life activity. Slide 17, the ADA. There are three titles of the ADA, and each applies to different types of entities and has a slightly different enforcement scheme. Therefore, it's important to know which title applies in which context. Title I applies to employment and prohibits discrimination in any aspect of employment. We're not going to discuss in much detail what Title I entails today, but we wanted to flag it because it's important for schools to know as employers that this section of the ADA implies. For example, where schools employ students in work-study programs, as graduate student instructors, as resident advisors. It's also important for students in internships or who are working in other jobs. Title II prohibits states and local governments from discriminating on the basis of disability in the services, programs, and activities that they provide. Therefore, Title II covers public IAGs, public schools. Title III of the ADA prohibits private entities or private businesses that are open to the public from discriminating on the basis of disability. This includes most, but not all, private colleges and universities. Religious entities are mostly exempt from Title III, but private religious schools are typically covered by Section 504 of the Rehabilitation Act. So you might be wondering, what are the differences between these titles and the rights that they secure? One major difference between Title II for public schools and Title III for private schools is that for lawsuits brought against private schools, a party cannot receive monetary damages. They can only request injunctive relief. So that's legalese, basically meaning that a lawsuit could only require the university to stop discriminating or to change policies and practices. When the ADA was passed, Congress granted the Department of Justice authority to issue regulations and guidance that interpret the ADA and to enforce the protections of the ADA. Department of Justice regulations have the force of law. Their guidance statements, however, do not, but they advise the public of the agency's interpretation of the statute. DOJ also investigates complaints of discrimination under the ADA and sometimes will file lawsuits. The results of these investigations, settlement agreements, resolution agreements, they often take different names, but that's a good clue to understand the department's interpretation of the ADA as well. So next we'll talk about Section 504 of the Rehabilitation Act. Slide 18. Section 504 applies to all recipients of federal financial assistance, sometimes FFA for short, but we'll try to say it out while we're speaking on this presentation. Section 504 prohibits recipients of federal financial assistance from excluding or discriminating against people with disabilities. Federal financial assistance basically means any money from the federal government. It can include grants, loans, or contracts. A good rule of thumb for our purposes, if a school accepts federal student aid or the FAFSA, it's covered by Section 504, and that's 99.9% of all universities, institutions of higher education, and otherwise. So the Department of Education enforces Section 504 in the context of education and has authority to issue regulations and enforce its protections. The Department of Education also has authority to enforce and interpret Title II of the ADA for public schools. That's a little bit confusing, but the important thing to note is that you'll often see guidance interpreting both the ADA and Section 504 that comes from the Department of Justice and the Department of Education together, the government actually collaborating, if you can believe it. But for our purposes today, we'll treat Section 504 as functionally the same as the ADA. Just know that there may be some very slight differences in the elements required to prove claims of discrimination under each law. I'll note one of those a bit later on in the presentation. Slide 19, components of a disability discrimination claim under Section 504 and ADA. So, what amounts to discrimination on the basis of disability? We find that it's helpful to picture this as 5 separate components that each must be met. First, a student must have a disability, and a disability is a physical or mental impairment that substantially limits one or more major life activities. Major life activities include things like learning, concentrating, thinking, caring for oneself, interacting with others, all things that are certainly a part of a student's experience in higher education. A disability substantially limits a major life activity when it restricts a student's ability to perform it as compared to most people. So, if a student's disability makes it harder for them to learn, concentrate, or participate as compared to most other students, it counts. Mental health disabilities that should easily qualify include those that Monica listed earlier, like major depressive disorder, anxiety disorders, post-traumatic stress disorder, bipolar disorder, to name a few. Second, the student must be otherwise qualified to meet essential requirements of participation. These essential requirements are the academic and technical standards of the school. In other words, core learning outcomes or skills and knowledge that all students must demonstrate. A few questions that courts have found helpful when determining what is an essential requirement of the school include questions like, what is the course of study designed to do or to measure? What traits or skills are crucial for professionals to demonstrate in their practice or profession? Essential requirements can be defined quite broadly and include things beyond academics. For example, the Fourth Circuit has held that professionalism is an essential function of the medical school environment. The Department of Justice has said that the school must show that the student has actually failed to meet this essential requirement, or show that it has legitimate concerns about a specific standard that the student cannot meet. A school can't simply say that a student is unqualified because of a generalized concern or fear. Next, the student can show that they can meet these essential requirements with or without a reasonable accommodation. This is really important, so I'll highlight again. They can show they are qualified to meet an essential requirement with a reasonable accommodation. So is there a reasonable accommodation that could help the student meet these core functions? If so, it must be provided. To put it in a different way, again, because this is so important, it's discrimination to exclude a student with a disability if they are unable to meet an essential requirement without a reasonable accommodation, if the reasonable accommodation would help them to meet that requirement. At least one court has found that if a student has met an essential requirement in a past semester without a reasonable accommodation, that's helpful evidence to show that the student could meet the requirement in the future with a reasonable accommodation. So specifically in the case I mentioned, a student was able to meet professionalism standards in the past in prior semesters without accommodations. So the court found that she would be able to meet the same standards in the future with a reasonable accommodation because she was able to meet them in the past. So what are reasonable accommodations? Question of the hour, I am sure. Slide 20, we think that it is helpful to think about accommodations in 3 buckets. So first, what most people probably think of when they imagine what an accommodation entails are auxiliary aids and services. So these are accommodations that look like and include things like a private location, alternative environments for testing, real-time transcription services. Second, accommodations also come in the form of modifications to academic requirements. So this includes things like modified deadlines for exams and assignments, or additional time to complete projects. A reduced course load or alternate work assignments are also modifications, and virtual learning or opportunities to work from home. We'll say more about that a bit later on in the presentation. Third, and less frequently thought about, are reasonable accommodations that modify policies and procedures. This is where a lot of action has focused recently in courts and with the federal agencies that interpret these laws. So modifications to attendance and absence policies can be a reasonable accommodation and is one that the Department of Justice has recently recognized. Related to housing, changing roommates or rooms, or allowing guests to stay in a room. It also covers rules and regulations that govern leaves of absences, which universities sometimes impose on students with disabilities. We'll discuss more on that later. It also covers policies that apply to withdrawing from courses or disciplinary policies. So these are all examples of things that students should be able to request a reasonable accommodation for. For more examples of what reasonable accommodations we have seen and what courts have recognized, you can refer to Bazelon Supporting Students Model Policy, which will be sent to participants after this presentation today. So back to the elements of a discrimination claim now that we've discussed reasonable accommodations, slide 21. To recap, we've discussed 3 of the 5 elements required to prove discrimination on the basis of disability. First, the student must have a disability. Second, the student must be qualified to meet essential requirements of participation. And third, the student can show that they are qualified with a reasonable accommodation. Now we'll discuss the final two elements. Fourth, the student must be excluded from participation, denied benefits, or discriminated against in any other way. A student is excluded from participation when the student is dismissed, put on a leave of absence, or when the student is not admitted to begin with. What it means to deny benefits differs a bit by jurisdiction, but it includes denial of accommodations that would offer a student an equal opportunity or meaningful access. Discrimination also includes a school's failure to make adjustments or modifications to academic requirements, which are necessary to ensure that the requirements do not discriminate or have the effect of discriminating, otherwise known as a failure to give a reasonable accommodation. Other forms of discrimination include things like using a policy that tends to screen out people with disabilities, failing to administer programs in the most integrated setting, or imposing a surcharge on a person with a disability for accommodations. The fifth and final element of a disability discrimination claim is that the school excludes the student on the basis of the student's disability. This is where I mentioned earlier that the standard differs a bit between the ADA and Section 504, and it's a little bit tricky. Section 504 requires that the school made its decision to exclude, deny, or otherwise discriminate solely by reason of disability. So in other words, there is no other factor that motivated the school's decision to exclude the student. In contrast, the ADA requires that the disability played a motivating role as opposed to solely is the reason. So a motivating role in the exclusion. This seems to be a bit of a lower bar in the ADA. Indeed, a recent case actually found that the ADA only required the student's disability to be a related reason to the exclusion. Again, this is super tricky because courts differ in their interpretation and whether or not they even interpret these statutes to mean different things. So it's important to note that even if the disability is remotely linked to the school's decision, it may pass muster under both laws as disability discrimination. So that's a lot on ADA and 504, maybe more than you ever wanted to know, but I'll pause there and give folks a chance to ask any questions before I pass it back to Monica to discuss the Fair Housing Act.
Hi, we did have a couple of questions come in. So one kind of ties in, I think, a little bit to the surcharge question. Who's responsible for paying for an accommodation?
So the university is responsible for footing the bill for an accommodation that is deemed to be reasonable. The comment about surcharges really has to deal with when a student is excluded from school and perhaps there is some sort of financial implication to that exclusion. There can't be an unfair surcharge that is imposed upon that student as it's related to another student without a disability. And Monica will say more about this later on in the presentation when we talk about affirmative defenses. So it is an affirmative defense that universities can raise to say that a reasonable accommodation is too expensive. But courts don't tend to agree with most expense-related defense claims because it is the university's responsibility to reasonably accommodate students with disabilities.
So one of the most common questions we get at the center is, but can you explain what reasonable is? When is it not reasonable? So could you give a couple of concrete examples of that?
Sure. Again, the courts sort of differ on what amounts to a reasonable accommodation. And the most important factor is that what is reasonable is a very individualized inquiry. So it's not reasonable if one of these fundamental alteration defenses, undue burden defenses that Monica will talk about in a second, would preclude the university from providing this accommodation, but that's a really high bar to meet. So most accommodations are reasonable for students with disabilities, and the accommodation should provide some sort of equal access to opportunity or an equal chance to benefit for students with disabilities. But the most important factor in this question is that it is individualized what is and is not reasonable. So I know that's not exactly the direct answer you're hoping for. But Monica, do you have anything else to say in response to that question?
Just that these are great questions and you all are tapping into exactly what makes these really tricky to work through. So what we're going to be doing next is providing an overview of the final federal law that we'll cover today. And then we're going to switch gears right into the nitty-gritty of working out what can make an accommodation reasonable. But before we do that, are there any additional burning questions?
That was very helpful. Thank you. Yeah, that's one of the toughest, the best and toughest parts of the ADA is case by case basis. So we had a couple of more specific questions about, say, documentation or some examples of accommodation. I don't know if you want me to hold those until later or go ahead and read them now, but you might be talking about documentation in a bit. So
yeah, let's maybe hang on to those. We're going to
Okay.
take another break right after this next section.
Right.
All right, Monica, I'll pass it back to you.
Great. Thanks, Britt. So on to slide 22, where we will cover the final federal law for which we will provide an overview this afternoon, which is the Federal Fair Housing Act. The Fair Housing Act prohibits discrimination in housing on the basis of race, color, religion, sex, familial status, national origin, or, especially for today's purposes, disability. The Fair Housing Act defines disability the same way as under the ADA and Section 504. We are talking about the Fair Housing Act in the context of campus mental health because the Fair Housing Act applies to dorms and college housing, and therefore institutions for higher education could be housing providers subject to these requirements. In addition to the ADA and Section 504, states may have stronger laws that provide greater access to housing than the Fair Housing Act. Since today's presentation is a national presentation, we will focus on the federal floor of rights and responsibilities. Moving on to slide 23. Under the Fair Housing Act, discrimination could take any of several forms. It could mean discrimination in the sale or rental or otherwise excluding someone from housing on the basis of disability. An example of this might mean evicting someone from campus housing after they have experienced a mental health crisis. That would be discriminatory. It could mean discrimination in the terms, conditions, or privileges in sale or rental of housing. An example of discrimination here would be placing additional conditions on a student to return to housing after they have taken a mental health related leave of absence. And we're going to cover leave of absence in greater detail during this presentation. Another example of Fair Housing Act discrimination might be discrimination in how housing services or facilities are made available to residents. For example, it would be discriminatory to exclude someone with a service animal from the common areas of housing. And we'll cover service and emotional support animals more today as well. Finally, and we've already started talking about this in the context of the ADA and Section 504, discrimination under the Fair Housing Act includes a refusal to make reasonable accommodations. Let's talk more about reasonable accommodations on slide 24. Since policies or practices might have a different effect on people with disabilities than on people without disabilities, there are instances where treating people with disabilities exactly the same as others might effectively deny them equal access to housing. Therefore, The Fair Housing Act requires making reasonable accommodations when necessary to afford people with disabilities equal access to housing. So what makes an accommodation reasonable? Similar to the rules under the ADA and Section 504, there must be an identifiable relationship or nexus between the requested accommodation and the individual's disability. And the accommodation, as we have started talking about, does need to be reasonable. So not an undue financial or administrative burden, nor a fundamental alteration of operations. And I promise I'll get to it in just a couple of slides. The accommodation, as Britt noted, may involve some cost to the housing provider, and housing providers may not pass on those costs in the form of requiring people with disabilities to pay extra fees or deposits as a condition of receiving a reasonable accommodation. To identify what is reasonable, because this can be challenging, it may require engaging in an interactive process to identify an accommodation that meets the need without posing an undue burden. This might require some time and effort here, and if no agreement can be reached through an interactive process, it is in effect a decision by the housing provider to not grant the requested accommodation, and a resident could then pursue a Fair Housing Act complaint. Britt talked you through some examples of reasonable accommodations under the ADA and Section 504. I want to open it up to our participants today. If you'd like to share in the chat to hosts and panelists, what are some examples of reasonable accommodations that might take place in the context of housing? And I'll pause to give folks a chance to think about it. I'm seeing some great examples coming through already. Emotional support animals, a roll-in shower, grab bars, or a room on the first floor for mobility disabilities, having a private room, having automated doors, private bathrooms, or I'm currently located in a part of the country that is experiencing a heat wave, air-conditioned rooms. These are all really great examples. Thank you all so much. So now let's continue to talk about reasonable accommodations on slide 25. First, I will talk from the student's perspective about the process for requesting a reasonable accommodation. And then I will talk from the school's perspective about processing a request for reasonable accommodation. So here we are on slide 25 for students requesting a reasonable accommodation. Generally, I'm going to go over today the rules and then the kind of practical application. If a housing provider has a reasonable accommodation policy or process, it is probably smoother to go through that process. However, it is not required that you make a reasonable accommodation in a particular manner or at a particular time. A student may, or any resident really, may request an accommodation at the application stage or at any time during their residence. It is better to request an accommodation in writing for record-keeping purposes, but you can also request an accommodation orally. You can request an accommodation yourself, or someone else can request it on your behalf. And there are no magic words here. You don't need to mention the Fair Housing Act or even use the words reasonable accommodation. You just need to make sure that a reasonable person would understand that you are requesting an exception, change, or adjustment to a policy or practice because of a disability. You'll want to explain the kind of accommodation that you're requesting, and if the need for the accommodation is not readily apparent or known to the provider, you'll need to explain the relationship between the requested accommodation and the disability. Let me pause to explain what I mean here. An example of an accommodation that someone put in chat was having a roll-in bathroom. An individual who uses a wheelchair or otherwise has an apparent mobility disability may need some modifications in order to be able to use all of the elements of their housing unit. This would be more readily apparent to the person who you're requesting it from. However, in the context of mental health disabilities, these are often what we refer to as invisible disabilities. What I mean by that is when someone is looking at you, they might not realize that you are a person with a disability, and so you may need to provide them with a little bit more information. I'll talk a little bit more in a few slides about exactly how much information is or is not needed. But the takeaway that I want to impart on you at this time is that in order to receive an accommodation, you do have to request it. Residents are not entitled to accommodations that they do not request. So now we've talked about students requesting a reasonable accommodation. Let's go to slide 26 to talk about how schools can process a request for a reasonable accommodation. Housing providers have an obligation to provide prompt responses to a reasonable accommodation request. An undue delay may be deemed a failure to provide a reasonable accommodation. As I noted earlier, you don't need to have a formal procedure for accommodations, but it does help to have one in order to avoid misunderstandings and keep accurate records. However, if you do have a formal process, you can't refuse an accommodation request just because the individual making the request didn't follow those written procedures. Accommodations can still be requested in any manner at any time. Now let's talk about the information that you can request when considering a reasonable accommodation. Generally, this is only the information that is necessary to evaluate if a requested accommodation may be needed due to a disability. There are three prongs here. First, information to verify that the person meets the Act's definition of a disability. Second, a description of the needed accommodation. And third, the relationship, or that nexus word again, between a person's disability and the need for the accommodation. And again, as I said, if the disability is obvious or otherwise known to you, or the need for the accommodation is readily apparent or known to you, you can't request additional information because that would make the process too burdensome. And of course, it goes without saying, but I'll say it anyway. There is a very important duty to keep any information confidential and only shared on a need-to-know basis in order to process the request. So now we've discussed three federal disability rights laws: the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, and the Fair Housing Act. We've talked about the elements that are required for proving a disability civil rights claim. And we've started now talking about, through our Q&A, what exactly the limits are of students' rights and schools' responsibilities, and where are those lines. So let's talk now, starting on slide 27, about affirmative defenses. There are three affirmative defenses to disability rights laws that we will review today, each of which provide a framework to be applied on a case-by-case basis. The first is fundamental alteration. An accommodation is not reasonable if it fundamentally alters the service, program, or activity. It would be a fundamental alteration, for example, to require creating new programs or curriculum. But it would not be a fundamental alteration to modify a policy that's peripheral to a program or service. For example, it would not be a fundamental alteration to provide a student with extra time on a test that is meant to test subject mastery and is not meant to test reading or processing speed. The second affirmative defense, and this has already been coming up for us in chat, is undue burden. This could be an undue financial burden or an undue administrative burden. As with fundamental alteration, this is really determined on an individualized case-by-case basis, and courts tend to look at an entity's financial and staffing resources. So, for example, to take a kind of extreme example, comparing a mom and pop store to a big box store like Walmart or Target. You wouldn't require a mom and pop store to put in an elevator, but you could require them to make aisles far enough that a wheelchair can get through, or potentially to put in a temporary ramp. Whereas for a store like Target or Walmart, which has much greater financial and administrative resources, the expectation is that they would have more sophisticated accessibility measures. I know that we've already had a lot of questions in chat about this, and I don't want to tamper them too much, but as a spoiler alert, in the case of many, what about this, what about that? Our answer is most likely going to be, it depends, because for all of these, they are really considered on a case-by-case basis. Before I pause for questions, I'm going to cover one more affirmative defense, and that is the affirmative defense of direct threat. So let's proceed to slide 28. Here's where it gets really tricky. And first, why are we talking about direct threat in a campus mental health presentation? Public entities, including schools and universities, may impose legitimate safety requirements that are necessary for safe operation of services, programs, or activities. So you're not required to permit someone to participate if they pose a direct threat or a significant risk to the health or safety of others that cannot be eliminated by a reasonable modification. That was a big sentence, so let's zoom in on it. It would have to be a significant risk to health or safety of others that cannot be eliminated by a reasonable modification. This is, again, determined on a case-by-case basis and needs to be based on actual facts, not on mere speculation, stereotypes, or generalizations about people with disabilities or people with mental health disabilities specifically. To determine whether a direct threat exists, entities must conduct an individualized assessment that is based on reasonable judgment and relies on current medical knowledge or on the best available objective evidence. Some examples of the best available objective evidence would be someone's current conduct or a recent history of overt acts. The goal of the individualized assessment is to determine three things. First, the nature, duration, and severity of the risk. Second, the probability that the potential injury will actually occur. Third, whether reasonable modifications of policies, practices, or procedures would mitigate or lessen the risk. For example, would it lessen the risk to allow a student to go to part-time, to change their housing so that they have a private room rather than live with roommates, or to allow a service or an emotional support animal? Additionally, when an entity is evaluating a recent history of overt acts, housing providers must also take into account whether the individual has received intervening treatment or medication that has eliminated the direct threat. If so, the housing provider may request that the individual document how the circumstances has changed such that they no longer pose a direct threat. This entire time, I have been talking about direct threat to others. Now let's proceed to slide 29 for a brief note on direct threat to self. And here's where it gets especially tricky. The text of the law does not support discriminating against someone who poses a threat to themselves. Unfortunately, case law does get murky here, especially in the context of higher education. It is unclear at this time whether schools can exclude students from campus, dorms, etc., if they pose a threat only to themselves. What is clear is that the determination must be based on an individualized assessment based on current medical knowledge. And therefore, schools cannot have a blanket policy, for example, that students with a diagnosis, a mental health diagnosis, cannot be admitted or live in the dorms. I recognize that this may have been the trickiest part of our presentation, and we've been holding off on some of these really challenging questions. So I'm going to pause here to see if there are any questions we can address at this time.
Hi, so it looks like some of the questions that we've gotten at this point are related to, accommodations overall. We had a couple of questions about, and I know this is often a tough one on campuses, when you are able to do a single room and, due to a disability, and then when is it not reasonable? For example, in one of the questions, they said, that students who requested single rooms in April have priority over students with disabilities who asked for a single room as an accommodation months later. So can you talk a little bit more about that type of accommodation?
That's a great question. Thank you. And that's an example of sort of accommodation inception, right? Because someone is requesting an accommodation in the form of a private room. And it may also be necessary to provide an accommodation to the first come, first served policy in terms of how private rooms are assigned.
So what you're saying is it's possible that they would not be able to then have a single room.
What I'm saying is that it might be an accommodation to allow someone to get a private room, even if they requested it later than someone else who requested it for a reason that was not accommodation related.
Got it. Thank you. And again, that's going to be something specific to the disability rather than a blanket accommodation. Got it.
Absolutely. These are all going to be a case by case basis.
So we had a couple questions here as well about, we had one to talk about, direct threat a little bit. If you could discuss suicide risks of students with mental health disabilities, and then the institution's responsibility for suicide prevention.
Absolutely. That's a great question. Thank you. So that's where we talked about the determination needing to be based on an individualized assessment of that particular student. So I recognize that it is tricky. We all read the news and have seen statistics, but it's really important that schools not make generalizations or stereotype based on mental health disability. Any assessment of a student's threat to him or herself or to themselves needs to be based on that particular student. We also didn't get into it in the slides, but it is recommended that if the student is working with a mental health treatment professional, that the school afford deference to the treatment professional's assessment of that student's health and safety. If they have treating professionals, they know the student best, and they should be active parts of that conversation and determination. Gotcha.
That's great. One more really quick, because I know you have a lot more slides to go. So one of the questions that sometimes comes up is if the campus staff is seeing or suspecting, that a student might have a disability, would they proactively offer one, or would that be something inappropriate to do?
sorry, proactively offer an accommodation?
Yeah, sorry.
Sure. So this is kind of outside of the purview of legal and kind of getting into the practical application of it. So one approach could be to offer to connect the student with your school's disability service office, if it seems like that is something that would be helpful to them. And then they can proceed with that conversation in that venue.
Gotcha. Thank you very much.
Thank you. These are really great questions. We promise to continue to pause throughout and share our contact information at the end, but appreciate Carlene noting for the sake of time, let's go ahead and move on, and I'll turn it back to Britt to talk to us about enforcement.
Great, thank you. All right, slide 30, enforcement. So now we'll turn, as Monica said, to a discussion on the enforcement of ADA Section 504 and the Fair Housing Act. In other words, what does a student do if they feel that they've been discriminated against on the basis of their disability? What processes should a school implement to investigate discrimination claims? And what role does the federal government play in investigating claims of discrimination under these laws as well? Slide 31, enforcement mechanisms. First, a school should set up an internal grievance procedure through which students can raise concerns about discrimination and bring them to the school's attention. These concerns include appealing denials of an accommodation or appealing any form of exclusion or claims of discrimination generally. Internal grievance procedures are usually initiated by a student's conversation with someone in the Office of Disability Services or an academic advisor, but they can also be more formal, like requiring some form of written petition. Title II entities under the ADA are required to have an Office of Disability Service, which is likely a part of this internal grievance procedure. But again, it could also be through an Office of Student Life or a Dean of Students. It's just important that there exists an internal grievance procedure. So again, this process might include things like a student being able to offer additional proof of their need for an accommodation, of the nexus that Monica mentioned between their disability and the accommodation, or their readiness to return from a leave of absence. The process might include an opportunity to discuss concerns before a committee of decision makers or having a third-party witness appear on behalf of the student. One important note about these procedures is that students can and should, if they need to, request an accommodation related to the processes involved. So those accommodations might look like additional time to prepare for a meeting in front of a committee, seeing questions that the committee will ask of the student beforehand so that the student can be prepared to answer them, or again, having a representative appear on behalf of the student. So these grievance procedures should also be set out in a university policy guide, and that is a best practice and occurs in the regulation from Department of Justice and Department of Education. So any deviation from the policy that is set out in some sort of a guide, and again, we're talking about this internal grievance procedure for appeals of denials or requests for accommodation, any deviation from the school's policy could be grounds for another claim of discrimination if the school treats the grievance procedure for students with disabilities differently from those without disabilities. It could also be grounds for a violation of a contract claim under federal interpretation of law in federal courts. The student handbook is seen as a contract between the university and the student, so processes laid out there should be followed, or it might be grounds for a violation of contract. And while it's not required to use these internal grievance procedures before asking the federal government to investigate a claim of discrimination, we always do recommend that a student exhaust, or in other words, comply with every step in the school's procedures. It's usually a much quicker way to resolve problems. There are always willing people within the university or school who are hoping to work with and solve a student's issues. And if the university then denies relief in these processes, the federal agency may be more likely to intervene. So as a best practice, we do recommend using these internal grievance procedures so that students are able to get the help and support they need more quickly. Next, I'll talk to you about how you can bring claims of discrimination to the attention of the Department of Justice, the Department of Education, and Housing and Urban Development for potential investigation. So this is another route to enforce your rights under the ADA, Section 504, and the FHA, so many acronyms. The route to bring and enforce those rights is to file a complaint with those various agencies responsible for enforcing regulations. So for private or public institutions of higher ed, you can file an ADA complaint with the Department of Justice Office of Civil Rights Division. So some agencies require that complaints be filed within a certain time frame of the last instance of discrimination. So the last time that the student felt that they were discriminated against. DOJ, however, for ADA complaints does not require that those complaints are filed within a certain amount of time. However, it's still a good practice to file as soon as possible and to file within 2 years for record purposes. You'll have the opportunity in each of these agency grievance procedures to flag if you believe the discrimination is still ongoing, if there's not a certain date that you can recall. For any school that receives federal financial assistance, which remember is all public and most private schools, you can also file a Section 504 discrimination claim with the Department of Education's Office for Civil Rights. You must file a complaint with the Department of Ed within 180 days of the last instance of discrimination, or you can demonstrate why you have good cause for not being able to meet that timeline. However, and this is important, if you do use the university's internal grievance or appeals procedure, you have to file a Department of Education complaint within 60 days of the use of that procedure. So 60 days for an example, if you appealed a denial of return from leave and the school still denied your return, you have 60 days from that date of denial to file a complaint with the Department of Ed Office for Civil Rights. For housing discrimination claims, you can file a complaint with the Department of Housing and Urban Development, and the timeline there is within 1 year of the last incident of discrimination. For all of these agencies, DOJ, DOE, and HUD, you can file your complaint using an online portal. We will send those links after the presentation today, but you can also mail in the complaint or call these offices if you need other accommodations for the typical complaint process. The form or conversation you will have with folks from the agencies will ask you to detail and explain to the agency what happened and identify the actors at the university who are involved. If you need an example of a complaint, Bazelon has one on its website as well. After the agency receives a complaint, they'll decide whether they want to pursue an investigation. So typically, this first initial step will include reviewing the complaint and likely interviewing the person or student who has filed the complaint to potentially ask the school for more information, ask for documentation about the specific incident. They might want to interview folks at the school or look at other records and documents as needed. This is important for students. The school absolutely cannot retaliate against you in any way because you have filed a complaint with a federal agency. And if they do, this is grounds for another claim of discrimination. So if after an investigation, the agency finds that the school has discriminated, the agency then may issue a letter of findings that spell out the violations if the school agrees, or they may bring a lawsuit to enforce the laws if the school still disagrees that there has been some form of discrimination. So this is the practice of federal agency enforcement of federal laws and is another tool through which the agency can provide info about how it interprets requirements under the law. So it's a really good idea if you're a school administrator to keep an eye on DOJ, DOE, and HUD websites for news of recent settlements and investigations to get a sense of how the agency is thinking about these laws. And finally, the last resort is federal litigation. And I do mean that as a litigator, it is the last resort. Usually you have 2 years to file a disability discrimination complaint against a school or university in a federal court, 2 years. Litigation takes a very long time. It can cost a lot of money, but sometimes it is necessary. However, again, it's always the last resort. So now we'll move on to barriers to enforcement of these laws. on slide 32. So beyond the length of time required for litigation, what are some barriers that students consistently face when enforcing their rights under these statutes in the courts? So there are a few ways, we've mentioned some already, that the law is still a little murky, or where courts unfortunately defer to some other lack of understanding about how disabilities can impact students in many ways that stretch beyond the traditional views of accommodations. So first, courts do tend to give what we call in the legal world as substantial deference, so deferring to schools when schools say that some requirement is essential to participation in their programs. So if a school says that demonstrating professionalism is an essential requirement of its program, courts will typically defer to the school's interpretation of what it means to show professionalism and how it measures professionalism, and not push back, even if that decision is pretty subjective. The same is true about decisions related to grades or promotion between levels. Schools get quite a bit of deference here. So another barrier, I've mentioned that the final element of a disability discrimination claim is that a school must have discriminated on the basis of disability. And what on the basis of disability means is a little confusing. So where courts apply the higher standard under Section 504, that discrimination occurs solely by reason of disability, it's really hard sometimes for students to establish that the school excluded them solely because of their disability, because the school could offer pretty much any other reason for its decision to deny the student an accommodation or to exclude that student. So the law does prohibit pretext. In other words, it's still discrimination if a school makes up a reason that's unrelated to the disability to cover up that the reason was related to the disability. But pretext can be difficult to prove. It's especially difficult to prove when a student's behavior, which is related to their disability, results in a code of conduct violation. So we've talked about accommodations from code of conduct policies, and we'll get more into that later. But this is an area where it's tricky. So a school could say that the dismissal or violation of a code of conduct is because of bad behavior and not the disability. So courts are becoming increasingly aware that bad behavior could actually be linked to disability and is just behavior that is a manifestation of a disability. Therefore, the decision to exclude a student based on that violation could be discrimination. So it's important to note. However, it's unfortunately not that obvious when schools are looking for disruptive behavior or bad behavior as a sign that a student can't meet an essential requirement. And schools often make the argument that there's a distinction between disability-related behavior and disruptive behavior. But we at Bazelon continue to push the interpretation that there is not a distinction in most cases. And we encourage all of the schools, universities, administrators on this call to really push your understanding of behavior-linked disability discrimination. So next, in the era of mass shootings and increasing media coverage of suicides on campus, there is a perpetuated fear of student safety on campus, as folks have mentioned in the chat. And with that comes a lot of fear and misunderstanding about how schools should be supporting students with mental health disabilities. So schools are probably a little bit quicker to claim that students are a direct threat to others or to themselves without necessarily understanding that accommodations could be provided to alleviate that concern, or understanding what the threat actually entails. So we've listed on the slide that one problematic tool and barrier to enforcement that schools often use are called threat assessments. And threat assessments are algorithms where administrators or school professionals can plug in certain characteristics or information into the algorithm to determine if a student is a threat to themselves or to others. Schools will often use these types of assessments to determine whether a student is a direct threat. However, as Monica said earlier, the direct threat analysis requires an individualized inquiry into the individual student's situation. So the use of these types of assessments that are not individualized are not compliant with the law and should not be used to determine whether or not a student is a direct threat and can therefore be excluded. So we wanted to flag that. There's often some confusion about whether threat assessments amount to this individualized inquiry, and we do not believe that they meet that legal threshold. So finally, we've also observed a trend in a lot of our work that schools often do not think that the law requires them to provide accommodations for past academic or behavioral issues, even when those incidents are later revealed to be linked or tied to a student's disability. So one example of these types of accommodations or retroactive policies are retroactive withdrawals, which Bazelon understands to be a reasonable accommodation in most cases. So here's a scenario. A student with a severe depressive episode isn't able to go to class and therefore receives a bad grade in the class because they weren't in attendance. So the student was not able to withdraw in compliance with the school's normal withdrawal policies during that semester, but later in the summertime receives a diagnosis of severe depressive disorder. And the doctor says that the student likely had that depression in prior semesters. The student requests an accommodation to change the bad grade to a W for withdrawal because of her disability. Yet the university denies that retroactive withdrawal request as a reasonable accommodation because the student did not have the diagnosis during the semester at issue. It came later. And the student did not request the accommodation before the semester began. So in this situation, we would advocate that the student should get a retroactive withdrawal as a reasonable accommodation, and the university's failure to provide it is discriminatory. So schools should keep in mind that often for mental health disabilities, especially, evidence of a disability often comes after a problematic incident occurs. This does not mean that the disability did not exist at the time of the behavior or that it is not the direct reason for the behavior. And schools should be willing to take in that new information to reconsider past decisions. Let me say this again clearly because we believe this is super important. Schools should be willing to take in new information about a student's disability to reconsider past decisions related to accommodations. So there should not be a distinction between future accommodations and retroactive accommodations, but this is still a barrier and remains somewhat of an open question where we continually advocate for more agency guidance. So I will stop and pause there on the discussion of enforcement and barriers to enforcement and open it up to folks to ask some questions.
Hi, thank you so much. That is a lot of dense information. Great information, but very dense. So I know that a lot of you have questions. We are running a little bit short on time at this point, but please, absolutely, any of us here at the ADA Center can answer ADA-related questions, and we're often also able to answer your questions about overlapping laws as well. So you can call us toll-free from anywhere, and it is a totally free call. At 1-800-949-4232. And then I think Monica has a couple of other suggestions for what to do, but we're going to go ahead and charge ahead. So thanks again so much.
Yes, thanks, Carlene. And in addition to the fantastic ADA centers, as we mentioned, state and local laws may differ. Carlene, could we maybe put that phone number in the chat for folks? And so in addition to reaching out to ADA centers, we also encourage you to reach out to your local protection and advocacy agency, or P&A. Every state in the union has one, and they will be very familiar with the disability rights laws in your area. So, as we mentioned, this is a lot of information. We're just over the halfway point. So as we transition to current trends on slide 33, I invite you to, as you're able, turn away from your computer for a minute, take a quick stretch break, roll around, do whatever is comfortable for you to get yourself ready to go for the second half of our presentation. We will be covering a handful of current trends this afternoon. The first of which pertains to service and emotional support animals on slide 34. Before I jump into slide 34, for anyone who is joining us by phone, thank you to Carlene for again sharing the ADA Center's phone number, which is 1-800-949-4232, or reach them online at adata.org. This information, along with the slides and some key links, will be sent out to all participants today. So let's jump into from the 101 portion of our presentation to the 102, current trends with service and emotional support animals. There's a lot of confusion about animals, so we want to break it down for you and distinguish them. A service animal has to meet a higher threshold and is allowed to accompany their human anywhere. An emotional support animal has a lower threshold to meet, but cannot go as many places. So to zoom in further, a service animal is a dog or a miniature horse that has been individually trained to work or perform tasks for an individual with a disability. For example, to alert a human with diabetes that their blood sugar is too high or too low, and it's time to take medicine, or a common one that we've heard with veterans with PTSD is to sweep an unfamiliar room to confirm that it's safe to enter. Service animals are trained to recognize and respond, to identify that a panic attack is imminent, and respond by applying pressure on the human's chest, as an example. Because service animals have this heightened training and are especially necessary, they can go anywhere that humans can go. For example, you might see a sign at a grocery store that says no pets, but service animals accepted. Compared to service animals, an emotional support animal does have a lower threshold to meet. It's any animal, and I do mean any animal, that provides emotional support, alleviating one or more symptoms or effects of a person's disability. For example, generally providing companionship, relieving loneliness, alleviating depression or anxiety or certain phobias, without necessarily being trained to do so. Housing providers are required to allow emotional support animals and service animals as an exception to a no pets policy. While there are places like workplaces or classrooms that can certainly open themselves up to emotional support animals, they're not required to. But again, service animals can go anywhere the human goes, including to class. Housing providers need to allow both service animals and emotional support animals. Neither of these animals, though someone might refer to them as a pet, legally they are not a pet, and they are an exception to a no pets policy. It does help to establish the need for an animal as a reasonable accommodation to maybe have a note from a treating mental health provider, but there are no specific certifications that are required. Vests are not required. There's a lot of internet scams out there that ask people to pay in order to get some piece of paper that is not legally required. So you want to keep an eye out for those and just make sure that they're meeting those 3 steps to establish the need for the accommodation. If someone requests an animal-related accommodation, the entity that's reviewing the request can ask 2 questions. If it's a service animal, they can ask whether the animal is required because of a disability, and what work or tasks has the animal been trained to perform. And if it's an emotional support animal, they can ask to confirm that the person has a disability and information that reasonably supports that need. I do know that we are running a little bit low on time, so I'm going to quickly jam through the next couple of slides to just hit on some of the main points. Slide 35 is related to voluntary leave of absence. We are going to be providing our model policy for supporting students that has recommendations on best practices for how to support students with flexible voluntary leave of absence policies. I really am going to start going faster now. Slide 36 is regarding involuntary leaves of absence. These should be extremely rare and are only lawful if a student cannot safely remain at school or meet academic requirements with accommodations and supports. Again, this requires that individualized assessment that we talked about. It might be related to that direct threat test about the nature and severity of the risk, the probability that any kind of injury would actually occur, and whether any accommodations could sufficiently mitigate the risk. A school should exhaust all potential accommodations before considering an involuntary leave of absence. Anything that might allow the student to safely meet academic standards and remain at school. Due process protections do apply. Students need to receive notice that the school is considering a leave and the basis for that consideration, have an opportunity for hearing and appeal, and be eligible to receive refunds for housing or tuition at the same levels and structures as students who take other forms of leave. It's important to not have any sort of blanket policies. These all should be conducted on an individualized assessment. And the involuntary leave of absence, if applied, again, in extremely rare circumstances, should end as soon as a student is able to demonstrate that they can meet academic requirements with or without accommodations. Slide 37, which we'll turn to next, specifically zooms in on returns from leave. We noted this in the context of current trends because this has been coming up somewhat recently. A 2021 settlement between the Justice Department and Brown University touched on returns from leave and noted that there had been dozens of undergraduate students who were denied readmission after taking mental health related leave. And so the Justice Department entered into a settlement with Brown that required Brown to make reasonable modifications to its return policies. Our supporting students model policy has a number of best practices, which we recommend and look forward to circulating to you. Additionally, from some recent letters and settlements with the Justice Department and the Department of Education, schools must allow students to return from leave as soon as a student can meet essential requirements. Schools cannot require engagement in employment or volunteer positions as a requirement for return, and cannot require students to demonstrate a decrease or amelioration of disability-related behaviors or symptoms. Finally, slide 38. There are a number of best practices for approaching leave of absence that we've mentioned throughout. Make sure to follow due process protections, limit confidential inquiries to what is necessary and appropriate, and provide similar policies and procedures, including those related to refunds and returns, the same for mental health leaves as non-mental health leaves. And of course, throughout, to provide reasonable accommodations in those processes. So now I'll turn it over to Britt for a couple more current trends.
Sure. Slide 39, I'll discuss for a minute the duty to engage in an interactive process. So in the employment context of the ADA, which is Title I, employers are required to engage in an interactive process with their employees when an employee requests an accommodation. So this process ensures that employees are not denying accommodations without considering individual circumstances. So while regulations and current law do not yet require that schools engage in an interactive process with students, they do have a duty to conduct an individualized process. That's a lot of I's, but let's dive into the interactive process. It's a best practice. And some courts have borrowed from Title I in the employment context and have found that schools do have this duty to engage in an interactive process with students. So both the Department of Justice and the Department of Education have recently had resolution agreements with universities that require these schools to establish an interactive process with the student beyond just an individualized assessment once the student requests an accommodation. So the interactive process should include things like identifying to the student who the decision makers will be when they're and who is considering whether or not the accommodation is reasonable, an actual meeting with the student to discuss an accommodation request and not just reliance on forms. The decision about an accommodation should be based again on the individual student needs. That's the individualized inquiry piece. And the school should provide written notice about the decision to the student within 1 week of the request. Again, that comes from guidance in an interactive process discussion that was related to a settlement agreement. So it's not in regulation per se, but this is a good indication of what the Department of Justice and Department of Ed think is reasonable when a student requests an accommodation, that the decision be made quickly within a timely manner, and ideally within 1 week of the request. So DOJ has also said that requests for accommodations should be considered in a process that is separate from other campus processes. So, for example, if a student has requested an accommodation from a professionalism policy and is at the same time facing proceedings for violating the code of conduct, these processes should happen separately. So the university should pause the code of conduct proceedings while the accommodation decision makers consider the request for accommodation. I'll move now to slide 40 to discuss quickly the code of conduct violations that we've mentioned a few times. So here are some examples of potentially problematic policies that universities have used to exclude students with disabilities for non-disability reasons. These policies include honor code violations or policies against academic dishonesty. Infractions here commonly include things like missing meetings, classes, or exams, cheating on examinations, so using assistive devices that might be needed after an accommodation is denied, not collaborating in group projects. Other policies against creating a hostile or intimidating environment are potentially problematic. Courts have said that the direct threat analysis, so determining whether a student is a direct threat to others, should apply when figuring out if a student has violated some sort of policy that they not create a hostile or intimidating environment. Finally, professionalism policies might also be suspect. Infractions here typically include things like arriving late or seeming disorganized. So one of Bazelon's current cases right now is against a medical school who dismissed a student with ADHD and cited to a long series of professionalism citations, including those I just mentioned, but also things like acting too informally with faculty and other peers, missing appointments, missing an exam, all behaviors that we have an expert who says are directly linked to the student's ADHD. So what's really important here is that students, when they request accommodations related to these policies, should explain to schools not just how their disability limits their academic performance, but also requirements of them in terms of behavior. So at least one court has said that a school doesn't discriminate if it's not aware of how the student's disability might impact the student's behavior, even if the school is aware of the student's disability and how it impacts the student in an academic setting. So students, just be as forthcoming as you can be about how your disability might impact your behavior. And universities, you should ask questions about a student's disability and the related behavior, not just in a classroom setting. I'll touch briefly on lessons learned from COVID, because what's a presentation in 2022 without discussing the pandemic? So there were lots of lessons learned from COVID-19 as schools were forced to adjust to a different delivery of classroom experiences and services. So it's harder now for schools to prove those affirmative defenses that Monica mentioned, that things like virtual technologies or working from home accommodations are no longer viewed as an undue burden, because universities were able to do them and students were able to succeed using them in the pandemic. So just important to keep in mind that schools should continue to make those accommodations available. And also, long COVID is now recognized as a disability, and includes things like having difficulty concentrating, in addition to more physical symptoms like fatigue, joint pain, et cetera. So there's some language here from a recent guidance document from the Department of Ed that discusses an instance of discrimination for long COVID that we would encourage folks to read. So I know we're running very short on time. This slide 42, we promised to get into a summary of some of these best practices. I'm not going to read through all of these because these are things that we have already discussed. But the best practice here for students is to disclose and ask for an accommodation. That creates a duty on the school to engage with you in an individualized process that should also be interactive with you. You should also make sure that you have read policies of the university and make your asks for accommodations specific to those policies, but know that it's not required to be formal. So if you've made it clear to someone, it's the university's responsibility to fulfill their obligation. Always ask for things to be documented in writing, and definitely make sure to keep a record of your conversations with folks. The best practice for administrators here is pretty straightforward. If we could say one thing, it's to create a trusting culture, to allow students with disabilities to feel safe to come and talk to you about their disabilities and their needs for accommodations. The MHA survey that Monica mentioned earlier in the presentation found that the top way schools can improve accessibilities is the first way is to train professors to understand what accommodations are available and to provide more outreach. So conduct outreach early during orientation, inform all of your students about the process for requesting accommodations. A student could experience a disability at any time in their tenure at the university or school, and they need to know what to do if that situation arises. The university should also take into account past individualized education programs, IEPs, or 504 plans that students had in place. Do not impose burdensome documentation requirements. Invest in peer-run groups and people with lived experiences to help students with disabilities navigate the accommodations process. And all of these factors will help you to create an environment where students can feel safe, heard, and protected. I'm on slide 45. We've laid out best practices for accommodations. I'm not going to run through these again. We've said them a few times. Just know that a student does not need to use magic words to request an accommodation. So faculty members should all be trained to know what to do when a request is made, how to identify the request, and where they should take that information. And finally, slide 46. Best practices for the administrative process. Review your policies and see which might be used to exclude folks on the basis of their disability. Allow new information about a student's disability to come in and inform past conduct. And do not use threat assessments. They're stigmatizing, and the direct threat analysis should be individualized. Monica, I will turn it back to you.
Thanks, Britt. We really appreciate everyone joining us for today's presentation, and we'll turn it back to our host to close us out.
Thank you so much. I couldn't have said it better. I want to thank everyone again for joining us. We are the Mid-Atlantic ADA Center. You can call us at any time with questions at 1-800-949-4232. That will route you by area code to the nearest ADA center. or you can reach us locally if you want to reach us directly at 301-217-0124. The email address here is adainfo@transcend.org. Monica and Britt, fantastic information. I want to thank you again so much. And we may have to ask you back so that you can go a little more in depth with those last few slides. But I think everybody got a lot of great information. So I hope everybody out there has a wonderful afternoon. Our next webinar will be on September the 21st on the topic of readily achievable barrier removal. So put it on your calendar. I hope everybody has a great day, and thanks again.